Welcome to Constitutional Chisme,
A law baddie's guide to the legal basics. I'm your host, Stephanie.
and I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week.
So today we are covering, drumroll please, Shoe Company versus Washington.
Someone actually guessed it this time.
We
and
did have
flew him
somebody
in.
actually guess it this time. We did.
Yes.
We flew him in. He's running late though, so he's not
Yeah.
here right now. But yeah, we went ahead and flew him in because we were so excited to have him guess it. So he will make a guest appearance at some point during the episode and let y'all know how he deduced what we would be covering this time.
Yeah, and he isn't a law student or anything. So he just guessed it based on all of the Easter eggs we gave on the last episode. So make sure you're guessing because it could be you.
Be you getting flown in. You never know. It's a really big week. Like, there's just a lot happening this week all around.
Yeah. First major shout out is I want to thank me for being born
Period. For
this
being
Saturday.
born.
Yeah.
You won't be born until this Saturday.
Yeah. So if any of you guys are listening, which I hope you are, I did go ahead because so many people requested this. May have only been my boyfriend's mom, but it's fine. I made an Amazon wish list of amazing
Yes, the
birthday
people were
presents.
demanding that.
Yeah.
Mhm.
I did send that
For
to your
sure.
man. He laughed.
He laugh reacted to it. He did not like that.
Yeah. Yeah. I did send it to him on his birthday, to be fair. So
Foul of you.
I
Foul
said
of
happy
you.
birthday first.
Happy birthday. Here's my list of demands.
Here's my birthday wish list.
List of
So
demands.
it's gonna be in the link. Okay, click the link. I'm gonna keep it the entire month of April. So if you're listening to this later on, you still have a chance to make my birth month special.
Congratulations. Yeah. And I know that you will feel so special.
You'll get a shout out.
So Stephanie's birthday is coming up April 4th.
Mhm.
She will be redacted years old.
Mhm.
And also on Saturday is another huge momentous occasion, and that is the 1-year sobriety of the very first guest on this podcast, Miss Rose. And I hope that she is so proud of herself. I hope she does something very special for herself because now I've had the opportunity to chat with her a little bit. And when I tell y'all that she literally deserves the world, she might be one of the kindest,
Yes.
most driven people. So huge, huge, huge shout out to Rose.
Yes. And I am going to attach on the link as well. If you would love to support her, right now I'm working with her. She might do an Amazon wish list, but if not, I was going to take if anyone wanted to donate on Venmo or Cash App, I was going to get that for her and send her everything because she is studying for the bar right now. Because she is when you're sober, and if you listen to her episode, she has that fire in her and she is ready to sit for the bar. So we're really, really proud of her. It's a big deal. And we can't wait to watch
Yeah,
her succeed.
and sending a little bit so that she has like some coffee or she can go out to like a nice dinner or something. Anything that you have that you're willing to give, help her celebrate. Because I'm telling you guys, you can tell just from her episode, she literally deserves the world. Such a kind,
Yes.
kind person.
I can't wait for her to be a licensed attorney because I know it's coming. I know it's going to be this year.
We're manifesting that for her.
So I'm really excited. We flew in last week's winner, Bradley. We're going to let him introduce himself and tell us how he guessed what the case today would be.
Hi, I am Bradley Somerville, husband of one of your wonderful hosts, and I figured out the clue by listening to Harleigh say in reference to Penolier v. Neff. This is not what we go by nowadays, but this is what everybody starts out learning because it is good foundational groundwork for personal jurisdiction. And I heard that and went, that's a weird way to say we don't listen to this anymore. So I looked up the next case that defined personal jurisdiction, which is International Shoe Co. versus Washington.
Great job.
And-
Congratulations.
Congratulations, Bradley.
All right. And I do want to thank our sponsor, Belmonte. I absolutely love their sugar scrubs and their lotion. So be sure to check them out. We're going to have them in the link below.
Yes, because the one thing about law school is you've got to set aside time for self-care. So, last episode, we discussed Pennoyer versus Neff and the effects that it had on personal jurisdiction, namely in the form of the territorial principle. Now, just as a quick refresher, the court held in Pennoyer that courts have personal jurisdiction over people who are within the borders of the state in which the court sits, or the forum state, but not those who are outside of those borders. Well, now, as things start to modernize a little bit, the court has to deal with the more intangible question of what that means when a person is both in and not in a state. And then in walks International Shoe Company. Dun, dun, dun. Okay, so getting into the facts of the case, we have the plaintiff, the state of Washington. So this is the first case, at least, that we've looked at where the state itself is a party to the lawsuit. So the state of Washington puts a tax on employers who are doing business in the state. And the reason that they did this was they wanted to provide a fund to be used for financial assistance for anyone who was unemployed in the state. So essentially, companies are paying a tax so that if there are people who are laid off, then they have something to fall back on. And the tax was a mandatory contribution to the state's unemployment compensation fund. Now, for a little bit of context here, International Shoe Co. was decided in 1945.
Okay.
So this is coming right off of the heels about, a couple of decades prior of the Great Depression and the market collapse, all of those things. So then you have International Shoe Company. Now, this is an American company that was incorporated in Delaware, but it had its principal place of business, or its PPB, in Missouri.
Isn't like every business incorporated in Delaware? Do you know why?
Yes. So the running gag is that so it's like a running gag that every company is always incorporated in Delaware because Delaware has the friendliest laws to corporations and makes for incorporation, basically ease of incorporation. But you can be incorporated under the laws of Delaware, but have your principal place of business somewhere else. So for instance, if you and I started a corporation together and we predominantly worked out of, say, Fayetteville, Arkansas, because that's where we went to law school. We could incorporate in Delaware, but if our brick and mortar store is in Fayetteville, then our principal place of business would be in Arkansas. So in this case, International Shoe Company was incorporated under the laws of Delaware and had its principal place of business in Missouri. Now, prior to International Shoe Company, the way that the court had addressed whether or not a corporation had jurisdiction was essentially only to look at those two factors, where it's incorporated and where it has its principal place of business. Typically, those were the only two places that that particular state would have jurisdiction over a company. Now, International Shoe Co. had about 12-ish salesmen in the state of Washington that were working strictly on commission, which means they only get paid if they actually make sales. They get a portion of their sales. So the salesmen were residents of Washington, and they were meeting with their customers in hotels and motels in the state of Washington.
They sell them shoes in the hotel lobby?
Yes, period.
That's so weird.
And occasionally they'd rent out space to put up these displays. Think when you're going to Walmart or something and there's the Girl Scouts are camped out in front of it.
Yeah.
So every year, these 12-ish salesmen are bringing in about $31,000. Allegedly, International Shoe System was set up explicitly to avoid establishing business in any other state besides where they were holding their primary place of business, which was Missouri. So they didn't have office spaces in any of these other states the salesmen were going to.
Is that why they would do the hotels, or they would do lobbies of different areas to avoid having
exactly.
Brick and
So there
mortar?
was no,
Okay.
like, permanent space that they were set up in. They wouldn't negotiate the prices, and all of the orders went back through their brick and mortar place in Missouri. Now, where this all gets kinda sticky is that International Shoe does not pay that tax that I talked about at the beginning. So they're not paying into the unemployment compensation fund.
Okay. Yeah.
So International Shoe Co. is not paying this tax, and Washington goes, "Hey, you've made, like, a lot of money in this state."
Yeah.
And that could have contributed a lot to this little fund here.
Yeah.
Oh, please
Fork it over.
give me my money. Money, please. And then they affect service of process on one of International Shoe Co.'s salesmen while he's in Washington.
Wait, so service of process again is they serve one of the salesmen, right?
Yes. So they give
Okay.
them the complaint and all the other required documents and basically say, here is everything. We'll go into everything that you need to do to properly affect service. But they properly affect service on one of the salesmen who's employed by International Shoe while he's in the state of Washington.
Okay.
And then they also send a letter by registered mail to that the principal place of business in Missouri.
Okay.
So they're covering all their bases. The state of Washington is making sure that they are covering their bases when it comes to jurisdiction. And International Shoe shows up, makes a special appearance before the Office of Unemployment to basically say, the state of Washington does not have jurisdiction over us. So special appearances occur in cases like this where you basically go in and argue your case, but you are not conceding the issue of jurisdiction. You're basically saying, I am not consenting to this court's jurisdiction. I'm showing up for one purpose and one purpose only, and that's to tell you, you can't touch me. Thank you,
Yeah.
Your Honor. Your Honor, that's crazy. But the trial court goes, hey, we really appreciate you showing up and saying all that, but we do actually have personal jurisdiction over you. That's crazy.
Mhm.
So because all of this is happening at the state court level, it goes up to the state appeal tribunal,
Mhm.
then the Superior Court of Washington,
Mhm.
then the Supreme Court of Washington,
Mhm.
and eventually gets appealed to the United States Supreme Court. So there's two avenues you can get to the Supreme Court. You can either go from federal court to one of the circuits to the Supreme Court, or
Mhm.
you can go through whatever the particular state process is. So there's trial court, there's some level
Mhm.
of appeal. Sometimes
Mhm.
there's more than one, but it has to go all the way up to the court, the highest court of that state.
Uh-huh.
Sometimes it's the Supreme Court, some states call it the Superior Court. Washington, in this instance, had both a Superior Court and a Supreme Court, but it has to go to the final court in that particular state. Then it can go to
Mhm.
the Supreme Court. So that's exactly what happened here. It
Mhm.
gets appealed to the Supreme Court, and the Supreme Court agrees to hear the case. So, Chief Justice Harlan Stone wrote the opinion in this case,
Mhm.
and he basically held that looking at 26 United States Code Section 1606A, which provided that no person shall be relieved from compliance with a state law requiring payments to an unemployment fund on the ground that he is engaged in interstate commerce. And he relied on that and the fact that International Shoe Co. is engaged in interstate commerce and basically says that does not relieve you from liability for payments to the state unemployment compensation fund. You still have to pay that money.
So just to be clear, interstate commerce means selling products across state, right?
Yeah, so this is anything that is moving from one state to another for the purposes of somebody making money off of it.
And
Now,
in this case was the shoes, right?
in this case, it was the shoes that International Shoe Co. is making. So, Justice Stone specifically said that the activities in question established sufficient contacts or ties between the state and the corporation to make it reasonable and just and in conformity to the due process requirements of the 14th Amendment for the state to enforce against the corporation an obligation arising out of such activities. That's a lot. Let me break that down. So essentially, what Justice Stone says is that you are doing so much in this state. You have made such constant contact with this state that it is reasonable and it does not go against the due process clause of the 14th Amendment for this state to now say, hey, you're here making money, so why wouldn't you also be liable in our courts? Why would our court not have jurisdiction to tell you you have to pay this tax when you are making money? So essentially, Justice Stone makes the point that this tax that's being imposed on corporations for the unemployment compensation fund was a tax on the privilege of employing salesmen within the state. And
Mhm.
because you are benefiting from that relationship, that's not a violation of the due process clause. Okay. So essentially, Justice Stone puts a lot of emphasis on the fact that the history of personal jurisdiction has been grounded in a court's power to rule over a defendant's person. And so
Mhm.
in this case, the fact that the corporation was present in the state did not go against the territorial principle that had been set up in Pennoyer v. Neff. And the fact
Mhm.
that the corporation didn't have a brick and mortar store didn't necessarily mean that they were not present for the purposes of personal jurisdiction. And he wrote that certain minimum contacts, such that the maintenance of the suit does not, quote, offend traditional notions of fair play and substantial justice.
So, just to confirm, this applies to anyone selling something in the state. Do people have to be there? Or, like, how does that work in terms of now we do everything online? You could order things online and get shipped over there. Would you still be within that
Yeah,
jurisdiction?
so the court will have to contend with that later on. But the short answer is yes. Once you avail yourself of the benefits of being within a state, typically that state can exercise personal jurisdiction over you. This case really evolves the idea of personal jurisdiction. So it goes from being cases related directly to subject matter to being extended to anyone who tacitly consents to jurisdiction. And the court basically decides in International Shoe that while still kind of adhering to this presence rule, while still sticking to the territorial principle, a state can exercise personal jurisdiction over someone who is out of the state, so long as that defendant has the sufficient minimum contacts with the forum state, and that the exercise of that jurisdiction will not offend traditional notions of fair play and substantial justice. And the court kind of breaks these down into more of a casual contact, like what you were saying,
Mhm.
versus systematic and continuous contact. So, for instance, if you sell, let's say, one pair of shoes in the state of California, that might not be sufficient to exercise personal jurisdiction. But International Shoe had these systematic and continuous contacts with Washington. I mean, they were making $31,000 a year in 1945.
Each salesman was, right?
Yes, exactly.
So, how does that work with fast food chains? Like, if you stop by and grab some food and you drive to the next state, would that give you personal jurisdiction?
Well, not to give you the most law school answer on the planet, but it depends. So the court does kind of look at this later on, and it has a lot to do with predictability. So if you take a larger chain like McDonald's, I had chicken nuggets just a little bit ago. They have it's more predictable for them to be hauled into court in more than one state
Mhm.
because it's obviously foreseeable and they have minimum contacts with just about all 50 states. I mean,
Yeah.
even in the smaller town that I grew up in, there are 2 McDonald's.
Yeah.
They're kinda everywhere. It's more reasonable for them to be hauled into court. Let's say if somebody buys a burger in Arkansas and drives across the border into Louisiana, and then they get food poisoning.
Mhm.
You can make a case a little bit easier versus, let's say, something like In-N-Out, which is more region locked.
Mhm.
It's
I love
a
In-N-Out.
little less predictable for, let's say, someone to buy a burger in Texas and then
Mhm.
drive 200 plus miles into Oklahoma or Arkansas and then say, well, you should have predicted that someone could eat your food and then drive into Arkansas and get food poisoning from it. That's a little bit of a harder sell. Not necessarily impossible, but a
Yeah.
little bit of a harder sell.
It probably tastes gross if you waited that long to eat it.
No, because why? I don't know what you're doing, putting your In-N-Out in the car and then driving across state lines to eat it. They ask you if you wanna eat in the car.
So, what's the holding for the case?
Yes. So, the holding in this case was that a suit cannot be brought against an individual or corporation unless they have minimum contacts with the forum state, and such lawsuit does not offend traditional notions of fair play and substantial justice. And specifically, to break down that holding a little bit more, the minimum contacts requirement basically breaks down into systematic and continuous conduct, or the activity is related to the cause of action. It has to be one of those two things in order to meet the minimum contacts test.
Perfect. Thank you for breaking that down. So
Yeah.
I just wanted to give another shout out. We are so proud of you, Rose. Congratulations on your 1 year sober.
Congratulations.
I also want to say happy birthday to me this Saturday. Make sure you check the link below because not only can you see my Amazon birthday wish list, you can see our Instagram, our TikTok, our Patreon. You can email me at legallyponzanelli@gmail.com.
And I also see those emails, so I can also respond if you have anything. And I was also going to say, speaking of like comments and things like that we get from listeners, we got a question about whether or not we are going to cover more modern cases and stuff that's happening before the Supreme Court right now.
Mm-hmm.
And I would love to. I think that that's so much fun. A lot is happening in front of the Supreme Court right now, and we would love to be able to touch on it because even if you are in law school right now, this is precedent that's going to affect you, if not in your legal career, if not needing to understand what's happening in your legal career.
Mm-hmm.
It affects us all as people who are in the United States. All
Mm-hmm.
of these things matter, even if
Yeah.
they do not matter to you personally, they do have impact on your life. So
Yeah.
I would love to talk more about it.
Yeah.
We will fit that in.
We might discuss doing 2 episodes, maybe a modern case and a old one.
I was about to say, I think advisory opinions and strict scrutiny call them emergency episodes, or whenever
That's
something
cute.
crazy happens, they're like, we have to talk about this right now, and they'll drop an episode out of nowhere.
Yeah. I also want to do celebrity cases. I think that would be really fun too. Like I'd love to go over the whole Taylor Swift one
No, because listen, and let
and
us
Cardi B.
know. I was about to say, I wish we had been doing this podcast when the Cardi B trial was happening. If that is something that you guys would care to listen to, I think I could talk about it until I'm blue in the face because
Yeah.
I don't know. Sometimes celebrity cases are just fun to watch.
Yeah.
The Cardi B trial specifically was fun to watch.
I love that she put her face from the courtroom on her album. That was
I
hilarious.
know.
She's
Wish I had
such an
gotten
icon.
one. I wish I had gotten one so bad. I regret it because that
Yeah.
was iconic, I fear. And to this
Yeah.
day, I still quote the she looks like she can guard a building. I mean, look.
Eh, Thank you for listening to us. And if you have some fun, new, and exciting cases that you want to hear, let us know.
Yeah, and thank you for listening, and we'll see you next week. Bye.
Bye.